and there's so much to get through today that I'll step right into welcoming everybody to this very important event. There's a huge turnout, which we're very excited about. Really, from all around the world. It's a topical and important discussion on environmental crimes and international law, current challenges and solutions, which I think keep changing by the day. Legal frameworks, landmark cases, and the role of international cooperation are some of the key areas that will be covered today. To provide us with some expert insights, we're privileged to have joining us a very distinguished panel of experts from around the globe, two of them in Nuremberg, one in The Hague. First up, Dr. Pauline Martini, who's a project officer with the International Nuremberg Principles Academy, who'll be speaking today on the principles of complementarity and environmental crimes. Pauline specialises in international criminal law and transitional justice, and is very well credentialed with an LLM in public international law from Leiden University and a PhD in international criminal law from Queen Mary University of London, which focused on the impact of the closure of the situation in Colombia of the ICC investigation into Colombia, which is where the preliminary examination, where no doubt she's gathered her expertise on the principles of complementarity, which she's going to speak to us about. I can see her nodding. She's worked also with the Special Tribunal for Lebanon and now takes a keen interest in researching the prosecution of environmental crimes under the Rome Statute, which is topical for today's discussion. Next up, we'll be hearing from Javier Ruiz, my colleague in the ICC Bar Association Working Group on Ecocide. He will be speaking on victim participation and reparations for environmental harm at the ICC. Javier is an international human rights lawyer and a researcher in public international law and international criminal law, and he's based in The Hague. He's an associate professor at the University of Mar del Plata, where he teaches international criminal jurisdiction and human rights. And he's also, amongst other things, a specialist in public international law at the Asser Institute and also at Groningen University in the Netherlands. And finally, Dr. Pablo Gavira Diaz, I hope I've said that properly, project officer with the International Nuremberg Principles Academy, and he'll be addressing environmental crimes and the protection of cultural heritage. Pablo is a Spanish lawyer who specialises in international humanitarian law and international criminal law. He holds a doctorate in international law from the Walter Schücking Institute for International Law at the University of Kiel, where his doctoral research focused on the international protection of immovable cultural property and the criminal liability for attacks against those objects in international law. It's such a wide and varied and quite a humbling group of people that we've got here today to talk to us. I'm absolutely ecstatic to be part of it. Before I go through the formalities, I'll introduce myself as well. I suppose I need to do that. So I'm joining you from Hobart in Tasmania, where I'm a barrister. I previously spent close to a decade at the Office of the Prosecutor at the International Criminal Court as a trial lawyer, where I worked on cases from the Democratic Republic of the Congo and from Kenya, amongst others, before returning to Australia. I'm very pleased to remain very involved with the International Criminal Court through the International Criminal Court Bar Association as the chair of the working group on Ecocide, and for the last 2 years as the ICC Bar Association focal point on sexual and gender-based violence. Locally, I'm the chair of the Red Cross International Humanitarian Law Committee, and generally I'm a human rights barrister. So with all the formalities out of the way and the introductions, I feel like we all know each other. Thank you all for joining us, what will no doubt prove to be a very informative session. There'll be some time for some questions at the end, so please use the chat functions, and I'll go through them at the end after everybody's spoken, and we'll stretch it out as far as we possibly can for that hour and 15, but we have to keep it to an hour and 15 today. I'll endeavour to put as many of them to the panel as I can. Now more than ever, the momentum is just so rapidly increasing when it comes to environmental crimes and on the international scale. But, speaking just from my own experience here in my hometown of Hobart, there's a huge flag with the word ecocide that flies in the middle of this historic city, which was raised by a good friend of mine, Penny. And a few weeks ago, our Pacific neighbours, Vanuatu, Fiji and Samoa, formally introduced the crime of ecocide for consideration by ICC states parties for inclusion as a 5th crime in the Rome Statute. This is huge in this world. There was a 50-year lead up to that. It didn't just happen overnight, but eyes from every corner of the earth are on what happens next. So without further ado, to speak on the principle of complementarity in environmental crimes, I give the floor to you, Pauline.
Thank you very much, Regina. First of all, I would like to thank the ICCBA for the kind invitation. It's a pleasure for me to be here. I will be sharing a PowerPoint presentation, so just give me 1 second so I can share my screen. Here, can you see it? Yes, wonderful. All right, so today I will talk to you about the principle of complementarity and environmental crimes. I'll start my presentation with a few preliminary observations on the relevance of this topic today. And then I will walk you through 4 challenges that I identified with regard to the implementation of the principle of complementarity in relation to cases or situations involving environmental crimes. And as we are talking about challenges and solutions, I will also put forward a few recommendations that the ICC could implement with regard to the principle of complementarity and environmental crimes. I wanted to start this presentation by talking about the relevance of the debate. Why? Because one may think, isn't it too premature to talk about complementarity nowadays in relation to environmental crimes, insofar as we're not even sure that the ICC could ever exercise jurisdiction over environmental crimes in the first place. So we know that complementarity is about the relationship between the International Criminal Court, ICC, and domestic courts. It was created to govern the relationship and to make sure that the ICC would remain a court of last resort. It means that the ICC only intervenes when states are unwilling or unable to do so. The principle of complementarity, as I'm sure you're all very aware of, has been translated into admissibility requirements in Article 17 of the Rome Statute. And the idea is that when there were domestic investigations, prosecutions, or trials, the ICC should not intervene unless the state is not genuinely carrying out these proceedings. It means that when we talk about complementarity, we talk about conflicts of jurisdiction. Complementarity becomes relevant when a state is investigating, prosecuting, or trying a case or situation that the ICC is also looking at. And in this sort of situation, the ICC has to make a determination on whether or not it can exercise jurisdiction. But when it comes to environmental crimes, we may wonder, do we actually have conflicts of jurisdiction? Because this idea, when it comes to environmental crimes, has 2 implications. The first one is that it would mean that states are currently exercising criminal jurisdiction over environmental crimes. And even though we have seen some progress in that regard, notably in Sweden, in Ukraine, it doesn't mean that it is a widespread practice at this stage. The reality is, state might decide to go for the civil or the administrative route instead of using, criminal courts to investigate environmental destruction and degradation. State may also decide to go after corporations, one of the main actors responsible for environmental degradation and destruction, instead of individuals. And there is also this whole debate within national courts as to whether national law include the crime of ecocide or not. The second, so we might wonder, well, why do we talk about complementarity if we don't have this widespread practice of states actually exercising jurisdiction over environmental crimes? And more importantly, the ICC is not doing it either. The ICC right now, there are multiple debates about how it should exercise jurisdiction over environmental crimes. And Regina mentioned that recent proposal for the inclusion of the crime of ecocide as a 5th international crime. But there are also debates as to whether the ICC should not use the crimes that are already incorporated into the Rome Statute and to interpret them in a different way, perhaps with more flexibility, more creativity, so that environmental destruction and degradation could be prosecuted as crimes against humanity, war crimes, aggression, or genocide. So the ICC could exercise jurisdiction over environmental crimes, but we're not quite there yet. So why are we talking about complementarity today? Well, I guess we're talking about complementarity because it becomes more and more relevant in a context where the ICC is more and more likely to ever exercise jurisdiction over environmental crimes. As you might be aware, in February 2024, so February of this year, the OTP, Office of the Prosecutor of the ICC, launched public consultations on a future policy paper on environmental crimes, showing that there is some openness on the side of the OTP to consider environmental destruction and degradation as existing core international crimes under the Rome Statute. So this is why we're here today. And bearing all of that in mind, I will talk about 4 different challenges that I identified. Obviously, the conversation remains abstract because we don't have any case law on admissibility with regard to environmental crimes at the ICC for the reasons that I've just mentioned. The first challenge that I identified relates to the idea of investigation. So as I mentioned, the ICC is not supposed to exercise its jurisdiction where states are or have been investigating or prosecuting the same situation or case. The issue with that is that the ICC has interpreted the term investigation in a very specific way. The ICC has said domestic investigations must lead to criminal prosecutions. If they don't, I disregard national proceedings and I maintain my jurisdiction over a case or situation. It means, and the ICC made it clear in decisions with regard to situation in the Philippines and situation in Burundi, that domestic, civil, or administrative procedures are irrelevant in its admissibility requirements. What does it matter with regard to environmental crimes? Well, an issue that we may face is that states might be more interested in going for the administrative route or the civil route to hold individuals responsible instead of going with the criminal route and investigating and prosecuting environmental destruction and degradation as crimes per se. So what should the ICC do if it ever has to exercise jurisdiction over environmental crimes? Well, if we want to avoid the ICC to over-exercise its jurisdiction in this kind of situation, the ICC might have to review the interpretation of the term investigation so that it would cover more than just criminal proceedings, that it would also encompass domestic investigations that lead to other type of proceedings. But that may lead to other issues, which is that you would have a different treatment, a different interpretation of complementarity, depending on the crimes that you're looking at, which would be a problem of consistency in the jurisprudence of the ICC. So in this context, we might want the Office of the Prosecutor to look at the question as to whether there are civil or administrative proceedings in a state under its interest of justice analysis, meaning that prior to opening an investigation over environmental crimes, the OTP should consider whether such civil or administrative proceedings at the national level would not bar an intervention of the ICC because it would be contrary to the interests of justice. Now let's move to the second challenge. The second challenge is still with regard to when the ICC should exercise or not jurisdiction. So when there is for a conflict of jurisdiction to exist between the ICC and national courts and the ICC must look at the same categories of perpetrators or the same persons. When it comes to environmental crimes, there are 4 main categories of actors. And this is something that Dr. Gavira and I identified together with other authors in a comment in response to the OTP call for public consultations on a policy paper on environmental crimes. And we identify the 4 main categories of actors as the following. We have state actors like head of states, armed actors, corporate actors, and members of criminal networks. For domestic proceedings to prevent an ICC intervention, they must be about the same categories of perpetrators that the ICC is looking at. An issue that we may face with regard to environmental crimes is that the ICC is not looking at corporations, right? Corporate liability is not an option before the ICC, which only looks at individual criminal responsibility. But what could happen is that state could look at corporations specifically under criminal law or under administrative or civil law. So then what would happen if a state is looking at a corporation, is investigating, prosecuting crimes committed by this allegedly committed by this corporation, and that the ICC is looking at the same facts, but from the perspective of the criminal responsibility of the CEO, individual criminal responsibility of that corporation? Should the ICC maintain its jurisdiction, or should the proceedings before the state prevent the ICC from intervening? Well, I think the answer to that is pretty straightforward, and I don't think that would cause much difficulties at the ICC, and that would be domestic proceedings against corporations. So proceedings at the national level should not bar an ICC intervention, in the sense that the state would be focusing on a corporation and the ICC would just focus on an individual. So we are talking about different entities, different people. Moving on now to my third challenge. So I was talking about this rule for a conflict of jurisdiction to exist. And I said, well, we need the domestic proceedings and the ICC proceedings to focus on the same categories of actors, same persons, but we also need them to concern the same patterns of criminality or the same conducts. It means that factually, the OTP or the pretrial chamber must look at whether the domestic investigations or prosecutions and the ICC situation or cases are about the same facts. In this assessment, the legal qualification that is retained by the state with regard to these facts is irrelevant in the ICC analysis. As you know, there is no obligation under the Rome Statute for states to adopt criminal domestic law that incriminates war crimes, crimes against humanity, genocide, and aggression. States are free under the Rome Statute to prosecute conducts that would amount to international crimes as ordinary crimes. And in principle, if they do so, it does not have any impact on the ICC admissibility assessment. It means that if a state, in principle, if a state that is willing and able to carry out proceedings is prosecuting a conduct as torture, and the ICC is looking at it as the crime against humanity of torture, the state should maintain its jurisdiction. However, the ICC has interpreted this idea of patterns of criminality and same conducts in a very strict way, in a very narrow way. And it's quite obvious from its recent decisions with regard to the situation in Venezuela and the decision to resume the investigation in Venezuela, where the ICC has actually taken into account the legal qualification that was retained by the state with regard to the facts. So the ICC, one of the set of facts that the ICC was looking at in its investigation was sexual and gender-based violence. And Venezuela was alleging that it was looking at the same facts, but qualifying them as torture and inhuman and degrading treatment. And the pretrial chamber confirmed on appeal said, well, actually, the qualification matters because prosecuting as torture is not protecting the same legal interests that are protecting if we prosecute something as sexual and gender-based violence. And on these grounds, amongst other observations and other findings, the ICC said it would maintain jurisdiction over a situation in Venezuela, right? I'm just putting it very simply. Well, if we apply that exact jurisprudence with this idea of legally protected interests into environmental crime cases, we might face an issue. Why? Let's imagine that the ICC exercise its jurisdiction over the crime of ecocide, that ecocide becomes the fifth crime under the Rome Statute, and that a state is prosecuting the same facts, for example, deforestation, as an ordinary crime, or as war crimes if it's committed in an armed conflict, then the ICC could say, well, you know what, the legal interest that is protected with ecocide is the protection of the environment. You're looking at the situation from the perspective of international humanitarian law. We're not talking about the same legal interest, so I should maintain my jurisdiction. The situation, the same could happen the other way around. The state could look at a situation under ecocide, while the ICC is looking at the same amount of facts, deforestation, for example, as crime against humanity of other inhuman acts. What would happen? The ICC would say, well, you're looking at the environment, I'm looking at the protection of, for example, indigenous peoples and sufferings that they feel because their habitat is destroyed. And there we have an issue. So my recommendation would be that this legal qualification should be completely irrelevant when it comes to environmental destruction or degradation. And that's actually a recommendation that I would have for the ICC jurisprudence on admissibility in a more general way. And I'm going to move now to my fourth and last challenge, which is about gravity. So now I'm going to move a little bit the focus out of this idea of the ICC shouldn't exercise jurisdiction too much to this idea of what if there is nothing going on, complete state inaction with regard to environmental destruction and degradation, and the ICC wants to look at it. And let's imagine that we're talking about deforestation. Deforestation that causes sufferings for example, indigenous peoples living in a situation. Well, for this situation to fall under the jurisdiction of the ICC, we would need it to reach a certain level of gravity, okay, which is assessed qualitatively and quantitatively looking at the criteria, the indicators that you can see on my slide. And the ICC could say, well, there are not that many people affected, nobody passed away, so should I really exercise jurisdiction? Well, maybe the case isn't as grave as it looks like. And so there is this whole question of how could the gravity assessment reflect the inherent gravity of environmental crimes? And my recommendation to that would be, well, we should take into account when it comes to environmental crimes, not only the local impacts, so the impacts of the deforestation on indigenous people, but also the regional and global impact, the impacts of deforestation on climate change. And that way we meet the gravity threshold established in Article 17(1)(d) of the Rome Statute. This is it for today. Thank you very much for your attention, and I'm looking forward to your question in the later on. Thank you.
Thank you so much, Pauline. That was incredibly informative, and I can't believe you managed to make something so complicated seem so digestible. So that's a real skill you have, and I'm sure there'll be some questions. There's some coming up already, but keep them coming, and we'll ask them to the different panel members at the end. Javier, I'll throw to you now. You're speaking on victims' participation and reparations for environmental harm at the ICC. The floor is yours, Javier.
Yes, I'm trying to share the presentation. Yes, we did it. Yes. You can see yes. All right. Regarding really good presentation, Pauline, thank you very much. Regarding in my topics, victims of ecocides and how does the impact of reparation regime in Rome Statute, I did an order of the presentation, key terms, anthropocentrism versus ecocentrism, well, the definition of ecocides, the role of victims before the ICC, victims participation, modalities and victims reparations, and victims participation reparations to environment and harm stricto sensu. I will really quick with the points number 1 and 2. Is Matthew Shillett always distinguish the key terms, the natural environment, the harm, anthropocentrism and ecocentrism and ecocide definition from the independent expert panel. I think that as a key term, I want to define anthropocentrism as a theory that denotes the prioritization of human interest and harm to human beings. And we have to say that international criminal law is essentially based on human-centered values and interests. Similarly, international humanitarian law. Regarding the ecocentrism, is a doctrine that refers to the prioritization of ecological values and the attribution of intrinsic value to the environment. No? The concept of ecocentrism essentially emerged during the 20th century. Highly recommend the working paper from Rebecca Hamilton at this point. The following, okay, with the definition. At the moment, we are the definition from independent expert panel, no, about ecocide means unlawful and wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. Independent expert panel from 2020-2021 suggests amendments to Rome Statute Preamble and Article 5.1 to facilitate ecocide being added as a fiscal crime. Well, this is one academic limitation that did Frederick Maigret, limitation the ecocide due to the nature of the context. No, international law, some issues involve some elements about sovereignty, and limitations due to the nature of the protect interest. Some academics is asking if we are in the new stage and we can talk about the international environment in criminal law. Okay, we are focusing this point, the role of victims, because before the ICC, victims participation, as we know, we have the important role of victims before the ICC as a significant element of the court, designed as a major big development of international criminal law. The recognition of the status of victims has implications for the intervention in proceedings and the scope of liability for reparations. And following this point, I put, and I want to remark the prosecution's 2016 guidelines about the case selection, when mentioned the vulnerability of victims and the social, economic, and environmental damage inflicted on the affected communities. These guidelines are really important. It's a significant development by the OTP ICC. Indeed, that it highlights the possible roles of the OTP of the ICC prosecuting environmental crimes, environmental damage, and still, well, as we know, still they don't. ICC can't expand the jurisdiction on the competence with this. Indeed, still we didn't include the ecocide in the Rome Statute. Following the victims' participation, the main topic is if the environment could qualify as a victim in its own right. The preamble of the Rome Statute recalls that millions of children, women, men have been victims of unimaginable atrocities. This is one of the shows that we have a Rome Statute involved in the anthropocentric frame. And the same happened with the definitions of victims, Article 68.3, and the rule of procedures of evidence, the rule 85.a, no? And regarding the modalities of victims' participation, happened the same when they say that Article 68.3 asks two kinds of requirements. First, if the victims are allowed to present their views in a manner that is not prejudicial to the right of accused and fair and impartial trial. And second, the participation of victims where permitted by the court must be carried out in accordance with the ICC rules. We have to stop and can see the jurisprudence of ICC. The appeal chambers in the case Lubanga, in the paragraph 62, has held that under Article 68.3 should be read in the light of Rules 85 and Rules 89.1, when say that the victim must show a link between the harm suffered and the crimes charged. Victims' reparations, to the victims' reparations, in this issue, assessing the applicability of the provisions and the jurisprudence of reparations to instance of environmental harms, we can do some analysis, look the reparations phase in the Al-Malfi case about the destruction of cultural heritage. Relation to environmental harm, the orientation of any reparations award would be both towards restoring the environment to its state prior to the harmful act and to extend there were human victims, individual compensation to natural persons. So it's one application of the UN Victims Declaration, the basic principle of justice for victims of crime from 1985. Following with the victims' participation and reparation to environmental harm structure census, we have to say that the applicability of the victims' participations and reparation systems to victims of crimes concerning the harm to environment raise several questions. First of all, whether that the environment can qualify as a victims or whether the victims regime would only relevant insofar as human beings and human organizations were impacted by environmental harm. Second, the need to show causation between environmental harm and the injury to individuals. Third, the means and mechanisms available to quantify environmental harm for the purpose of reparation through the compensation. So all these questions that try to focus to try to put environment status as a victim before the ICC. Two major implications emerge from this kind of analysis of the possibility of the environmental qualifying as a victim per se. First, the fact that there is no realistic means of the environment qualifying as a victim in its own right under the existence of Rome Statute framework indicates that the rule of victims' participation are conceived of anthropocentrically. Second, the inclusion of the environment qualifying for victim status per se is contradictory in the light of the Rome Statute inclusion of the crime under the Article 8.2.B.4, which refers to the harm to the environment. That means that the crime could be proven by the entity that the provisions try to protect can't qualify as a victim of the crime. The possibility of reparation for individual humans who have suffered personal harm as a result of environmental degradation, organizations that have suffered direct harm therefrom, there are multiple forms of consequent damage that may arise as a consequence of environmental harm. It's important having in mind the notion of consequence damage. An alternative approach to the issue of the victimization of the environment is to focus on the collective harm caused by the people when the environment is seriously damaged. Appeal chambers in the Lubanga case state that the collective nature of the harm is not relevant to the question of victim participation. In the case for the case Lubanga, the decisive factors are the personal suffering of harm by the victim and the type of harm suffered. The types of recognizable harm identified in the ICC jurisprudence, we are talking about the Lubanga case, are strongly anthropocentric, as they show a clear orientation towards individual human victims. For any harms and reparations, yes, for any harms and reparations, the nature of the harm must be established and documented. The reparations in the Al-Mahdi case, August 2017, indicates that the court would consider harm at two levels: the general harm to the international community caused by environmental destruction and the specific harm caused by the convicted person's crime. So we can start to conclude first, the natural environment doesn't per se match with the definitions and the rules of the ICC for victims, and so couldn't itself be considered a direct victims of crimes before the ICC under the current framework. This is the first conclusion. Second, however, there are circumstances in which human victims of the crimes involving environmental harm could qualify as victims in order to potentially participate in proceedings and receive reparation arising from their injuries. Third, the exclusion of the environment from the victim's status per se is contradictory at the light of the Rome Statute inclusion of the crime in Article 8.2.B4, which refers to natural environment. Fourth, an increase in the prosecution of environmental harm will result of an increased focus on the victimization of the environment. And the last three highlights is, this will be highlight the lack of provisions in the rules of victims' participation capable of applying to the environment in and of itself. 6. An explicit recognition of the environment potential victimization by acts prohibited under the Rome Statute would have been consistent with the 1985 UN Declaration of Basic Principles of Justice of Victims, we mentioned before. And 7, this principle direct that there should be compensation for environmental damage, particularly its restoration to the pre-damage state. However, this kind of restitution in integrum may not always be possible following environmental harm, and means damage may be required to remedy the harm. That's all. Thank you very much.
Thank you so much, Javier. That was great. And you've kept within the time limit. I'm very, very impressed.
Yeah.
I was told that I was to be the keeper of the time, and you've done well. Very much appreciate that. Thank you for that. Finally, Pablo, you're going to be speaking to us about environmental crimes and the protection of cultural heritage. I'm quite intrigued by this. So I'll give you the floor and look forward to hearing what you've got to say.
Thank you so much, Regina. Well, good afternoon, everyone. Greetings from Nuremberg. I am, as Regina already mentioned at the outset of this presentation, a project officer at the International Nuremberg Principles Academy, which is a foundation with a broad mandate. Very recently, the Academy has, undertaking sort of a new line of research on environmental crimes. And I have to say that the scope that I've chosen for this presentation is restricted to available instruments. So this means that I will not be covering today the so-called crime of ecocide, which is not yet a legal term. So that's why I will try to, if I may say, play with the cards that we have on the table to provide for a, let's say, a substantive contribution to what we see today when it comes to environmental crimes and the crimes against cultural heritage. The approach for today's presentation will be, again, merely informative. So I am planning to use easy, a very inclusive terminology, so everyone in the room will be able to understand the main developments, as I said, the main characteristics or aspects of this particular field. And of course, I will conclude with a wrap up, with a summary of the elements that I'm going to cover today, with a view to understanding the general context of this particular topic. Well, first of all, as my colleague Pauline already mentioned, this is basically the architecture that I will be addressing today. We're speaking today about the Rome Statute of the International Criminal Court, particularly, which is characterized, as you well know, by individual criminal responsibility. This means that corporate crimes or crimes committed by corporate entities are naturally out of the scope of this particular presentation. And as you well know, the ICC has jurisdiction over 4 crimes, which is genocide, crimes against humanity, war crimes, and aggression. And I will be addressing today only 3 of them, which is the genocide, crimes against humanity, and war crimes. I will try to stretch, or I will try to widen, so to speak, the Rome Statute of the International Criminal Court, like a chewing gum. I will try to see the possibilities that this particular text provides for the topic in question, to see whether this instrument provides for the same level of protection when it comes to crimes against cultural heritage and crimes against the environment. Well, the most important thing for you to know at this point is the framework. Does the Rome Statute really protect cultural heritage? Well, it does in a way, but there is no reference to the term cultural heritage in the Rome Statute. It refers to the protected objects, which is a term, let's say, included in the elements of crimes, but it's not in the Rome Statute, but in the elements of crimes. And let's say the word or the expression cultural heritage can be found in the World Heritage Convention, which was, as you well know, adopted in 1972, mainly with a view to being applicable in times of peace and not in times of war. But it provides for a very interesting definition of what cultural heritage is in Article 1. So it speaks of monuments, groups of buildings and sites, but with an outstanding universal value. So we are speaking about a certain characteristic here, about the value. However, when it comes to the Rome Statute, and as you can see in the slide in the second bullet point, the war crime of intentionally directing attacks against buildings dedicated to religion, etc., it speaks of a purpose. It does not pay attention to the value of the object in question. It speaks of buildings, of immovable and tangible property. And this is important to take into consideration. And it is for course, the Rome Statute protects this type of buildings as long as they do not qualify as a military objective. This is very important also to keep into consideration. As you know, as of today, we only have one case addressing attacks on cultural heritage, on cultural property, which is the Al-Mahdi case, which was, as you well know, in 2016. So when it comes to environmental crimes here, we see only one provision dealing with attacks against the natural environment, which is the term chosen by the Rome statutes to address this type of offense. You can see that there is no actually definition of such an, let's say, concept. I have added to the slide a few acts that might potentially be considered attacks against the natural environment. As you can see there, mass deforestation, scorched earth, water pollution, or even damage to infrastructure, which is what we probably have seen last year with the destruction of the Kachova Dam in Ukraine in June 2023. As you probably know, if you see in the slide, this particular provision applies only in the event of an international armed conflict. So let's say if we're speaking about a civil war, this provision would be inapplicable. If we speak about the term natural environment or natural heritage, the World Heritage Convention provides a very interesting definition in Article 2. So it refers to three types of heritage. It refers to natural features, it refers to formations, it refers also to natural site or precisely delineated natural areas. One very important distinction between cultural heritage and natural heritage as defined by the World Heritage Convention is like the cultural heritage is sort of a human-made nature, while natural heritage seems to be something, let's say, where humans have not intervened. And once again, natural heritage, according to the World Heritage Convention, must be of outstanding universal value. So the value is indeed a requirement to be considered to be protected by such a convention. What does, so we are speaking about this again, substantive, contribution of the Rome Statute, but what does the Office of the Prosecutor of the International Court have to say about environment? Well, it has at least since 2016, has expressed some interest in acts against the environment. I have, let's say, taken a few interesting reflections from the policy paper on case selection and prioritization published in 2016, with a special emphasis on paragraphs 40 and 41, where you can see that the attacks or the destruction of the environment was already a priority, was already on the prosecutor's agenda. And most importantly is the third bullet point that I have attached here. So when assessing the gravity of the crimes, the OTP is also looking at the manner of commission of the crimes, whether they were committed systematic or they were part of an organized policy, whether there was an intent to discriminate, and whether it was committed by means or resulting in the destruction of the environment or of protected objects. So you can see that the two topics that we're addressing today come together in this particular statement of the OTP. Pay attention to this systematic character of the crime. This is a very interesting term, which is also to be found in Article 7 of the Rome Statute, particularly speaking about the contextual element that you can see here. The second element, it says that to be a crime against humanity under the Rome Statutes, this particular act must be committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. Well, if we see a little bit, if we keep reading the provision, Article 7, the crime of persecution, including Article 7, paragraph 1, letter H, it refers to a very broad, very heterogeneous offense, which was, by the way, born in Nuremberg, exactly in the building where I am talking to you from. And it is defined as an intentional and severe deprivation of fundamental rights by reason of the identity of the group. This is the definition included in Article 7.2g of the Rome Statute. And as you can see, this particular crime can be committed against any identifiable group or collectivity on different grounds. One of the most important points to keep into account about persecution is the connection requirement. I have highlighted it in red, so this crime can only be committed in the presence of other crimes. It is not a standalone crime, as for example, the crime of genocide. It needs the so-called participation of other crimes to be qualified as such. This definition does not include the discriminatory requirement, but the discriminatory intent on the part of the perpetrator is the legal ingredient of the crime of persecution. And I have included in the slide a reference to the Kordic and Cherkes case, which is from the International Criminal Tribunal for the former Yugoslavia, which I'm going to read it right now. So in paragraph 207, the chamber said, and I quote, "The destruction of religious buildings, when perpetrated with the requisite discriminatory intent, amounts to an attack on the very religious identity of a people. As such, it manifests a nearly pure expression of the notion of crimes against humanity, for all of humanity is indeed injured by the destruction of a unique religious culture and its concomitant cultural objects." So you can see that the identity of the group is definitely a necessary element when it comes to the crime of persecution. And of course, this crime is, in my view, broad enough, expansive enough to cover acts which are not explicitly punished under the Rome Statute. The crime of genocide is always it provides for a very strict definition. Cultural genocide or even natural genocide, if I so to speak, was rejected, by the draft of Genocide Convention between 1947 and 1948. Cultural genocide is not today a crime under the jurisdiction of the Rome Statute. One could argue that, subparagraph C that you can see in the slide, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, could be interpreted in such a way so as to cover perhaps the destruction of natural resources of the land where a specific indigenous people live, those resources being essential for the survival of such indigenous group. Well, one could, provide this creative, this expansive interpretation of this particular subparagraph or Article 6. But again, I am not very, very convinced about this particular interpretation. To conclude, well, I would like to just to wrap up a little bit on what we have discussed today. We see that the Rome Statute provides for two different levels of protection. When it comes to cultural heritage, so to speak, we speak only about tangible and immovable property. It is, as you know, a war crime, and in international and a non-international armed conflict, it could, in my view, amount to a crime of cultural persecution as long as it is connected or as long as it takes place in a campaign against a particular civilian population where other crimes are involved. Remember the connection requirement. And when we speak about natural heritage, so this broad term of environment, well, it is at the moment a war crime, only applicable in the event of an international armed conflict, and could perhaps be a crimes against humanity of persecution if, again, the elements of discrimination, the elements of connection with other crimes, and the gross violation of fundamental rights of a particular civilian population take place. This is the only way I see an expansive interpretation of the Rome Statute. So what are the solutions if we don't have a specific crime such as the crime of ecocide? Well, I would always recommend to be particularly creative, flexible with the interpretation of the elements of crimes. And of course, we should not forget that the ICC is a court of last resort. So we count on state parties to do their job, to investigate and prosecute crimes committed within their jurisdiction or through the principle of universal jurisdiction. Thank you very much.
Thank you so much, Pablo. Very interesting, and I think, you know, there's still so far to go. I guess I'm going to absolutely take my liberty here and ask a question before I ask it the others. You know, when I worked at the ICC, I remember there was you know, the arrest warrant for al-Bashir, and you know, what was quite evident was that scorched earth policy, which we used in, you know, to support genocide and war crimes against humanity, I think, against al-Bashir and some of the others. And it was, I don't ever recall many discussions around whether or not we go down the environmental path. Now, I know that was 2009, I think, or 2000. It was very early days, and we were all finding our feet. And sometimes it's easy to charge what you can with your hands. But here we are, you know, in 2024, and it's still very light on. You know, what are your thoughts on? And I suppose I can open that up to anyone, but probably Pablo, you know, what are your thoughts on why that is?
You were speaking about the arrest warrants against al-Bashir. I think it's from the 4th of March 2009.
Oh, you're better than I remember it, but I can't because it was before 2010. There was, and then there was the appeal, and we got genocide after the appeal. Yeah.
That's correct. I have that particular document very fresh in my mind because, as my colleague Pauline mentioned, we submitted a comment on environmental crimes in March after the OTP called for several comments. And then we referred to that particular arrest warrants, to that particular on a potential case of environmental crime. So this was a very important development. At the time, perhaps, as you said, was overlooked. So, but definitely in my view, and then as we argue in the comments, that could be also a case of a potential genocide, because it seems that the target of such an action was a protected group. So, but again, this is, as I said, this comment and my presentation today is basically abstract. So the idea is to be particularly creative today so we can have some food for discussion.
Yes, and I appreciate your creativity, Pablo. I really do. Also, Pauline, you wanted to answer something to that as well?
Yes, please. Yeah, I think what's interesting with the al-Bashir arrest warrant is that at that point, we're looking at the environment being used as a means through which an attack or acts can be committed against the civilian population. And I think that was, you know, the idea of the policy paper of the prosecutor at the time. We are looking at, you know, the environment as a means through which, but now we can see things differently. We can see an attack against the environment having impacts against civilian population. And this is where, you know, the creative interpretation of other international crimes become relevant in the environmental sphere. So I feel like now we are more open-minded to this idea that the environment can have different impact on human and is tightly linked to human suffering. So we are just more open-minded, I think, to this idea. And that's why we're broadening the scope of the Rome Statute.
I completely agree with you, Pauline, and that is no criticism at my former colleagues who worked on Darfur or Nor Lewis. I know there were already enough issues and difficulties, and the fact we got genocide across the line on appeal, and it was the first and only, I think, arrest warrant with genocide at the ICC, is already a very, very good good thing. So I don't mean to criticize at all. It was just something that sort of, you know, we didn't think about it at the time, I have to say. You know, the scorched earth policy, of course, is horrific, but because I think also, you know, with so much more focus on environmental, not just crimes, but the environment now in the new generation, we're becoming really mindful of it. And that's a good thing. It's really important to be educated and to continue to think forward, and which is why I really appreciate, Pablo, the way you are being so creative around using the tools that we have to do this. I've taken my liberty now. That's my one question. I won't interfere anymore. I do have a couple of questions on the chat. So the first one, I think it came through while you were talking, Pauline. Can ICC invoke jurisdiction on environmental crimes as a statutory/advisory body?
Yeah, I'm not sure. Could that person specify what they mean with the advisory body exactly?
Yeah, I think the question, I think it's around the jurisdiction, is, you know, that the jurisdiction of the court is
Okay.
just for individual criminal responsibility rather than any other sort of advisory body, and that would fall with the ICJ, I think, is the answer to that, to the question that's been asked there.
Yeah, okay, yeah, and there is also this idea, and that's what we've been working on extensively, and with Pablo notably, that you can creatively interpret the existing crimes under the ICC statute to incorporate environmental destruction and degradation. Obviously, it requires more flexibility, more creativity, but we argue it's something that's possible, and there are some crimes, including the crime of genocide through the infliction of, you know, conditions of life, blah, blah, that is relevant, but you can think about persecution, other inhuman acts, you can think about pillage, you can think about destruction of property. And we think that there is room for the ICC to exercise jurisdiction through these crimes, yes.
Yeah. Okay, so the next one is also for you, Pauline. You still got the got the talking stick. The 4 challenges mentioned by Dr. Martini seem to me generally valid for all core international crimes, not only environmental crimes. Hence, my question is, what are the specific features of environmental crimes that warrant a different interpretation of complementarity for environmental crimes only? And if any, is a special regime of complementarity for environmental crimes different to that applicable to other core international crimes legitimate? I don't know if you can see the question as well,
Yes.
Pauline, because it's a long one.
Yes,
You've
I
probably
can.
got your head around it. Yeah, okay.
Thank you. Thank you, Matteo, for your question. I agree with you that other international crimes can also have broader impact than just local impacts, right? When there is a war, you can think about, you know, regional instability, migration issues. So issues experienced by, you know, other states than just the stake at hand. So you can think about the fact, well, the gravity of all crimes, you know, is terrible. And I agree. But when it comes to environmental crimes and gravity, you have to think about the impact that it has on health, right? We are talking about the right to life of everybody on the planet. We're talking about the right to a healthy environment. We're talking about the right to health. So that's why I think the approach of the ICC when it comes to gravity with regard to environmental crimes could be a bit broader, could be a bit different. When it comes to what makes environmental crimes so different than other crimes that would justify a different regime, well, I don't think it's that much about, I mean, except for gravity that I just explained, I think it's also about the state response that may be different with regard to, you know, finding individuals liable for these crimes. State can go with civil law or can go with administrative law just because from a criminal law perspective, proving that a specific act against the environment has had specific consequences on people's is very, very hard, especially with the beyond reasonable doubt threshold. It's extremely hard to prove because there is such a disconnect sometimes. And it's also very difficult because you have the mental element to demonstrate the intention, or even recklessness sometimes is not enough. So you have to prove that they could have anticipated that this would happen, right? So it means that state may decide to go with different routes than just going with criminal, you know, criminal law as an option. But then is it enough to justify a different regime at the ICC? I don't think so, because when you look at states going through transitional justice processes, the ICC seems to think that this is no exception to how it has been interpreted Article 17 so far. So that's why I thought, well, it's hard to, there are differences, yes. It's hard to justify and legitimize a different complementarity regime. And this is why I thought, well, maybe the answer is in the interest of justice clause in Article 53 of the Rome Statute that the OTP could use to justify a non-intervention and the non-opening of an investigation over a situation where the state is active, but from a civil or administrative perspective. Is it the right answer? I don't know. It depends on whether the ICC really focus on, you know, criminal liability, or whether the ICC would just be happy with states being a bit active, regardless of how they're active. Thank you.
Thank you. Good question and good answer. That's getting right into it. I've got another question. Now, this one I think is for you, Pablo. how does international law, such as the Hague Convention for the Protection of Cultural Property in Armed Conflict, ensure the protection of cultural heritage in areas affected by war, environmental crises, or political instability?
Thank you very much. That's a great question. Well, the Hague Convention that is usually known is an instrument of international humanitarian law. And as you know, this particular field of public international law deals with the so-called laws of war. International criminal law, which is another field under this big umbrella of public international law, deals also with, acts committed both in times of peace and in times of war. So when it comes to the Hague Convention, which is, in my view, the most developed instrument when it comes to the protection of cultural property, we need to take into account a few more things. First of all, it's a treaty that has to be ratified by the member states. Some of the provisions of this particular convention are a little bit weak, especially when it comes to the sanctions. What happens when states do not protect cultural property in the event of an armed conflict? What happens when the states do not take measures to protect such a property during time of peace? Well, Article 2 and 8 of that particular instrument is very weak. This instrument was supplemented in 1999 by the so-called Second Protocol. And this instrument in particular is, in my view, sort of an international criminal law treaty, because it provides for many provisions related to individual criminal responsibility. So what is important for you to know, Ratna, is like the Rome Statute does not or was not influenced by the Hague Convention. So if you pay attention to Article 8, Article 8.2b9, and Article 2e4, these are influenced by the so-called Hague regulations of the Fourth Convention from 1907. These, particularly speaking, Article 27, Article 56 are those provisions where the Rome Statute drew influence from. It does not refer to the value of the object in question, as it is the case of the Hague Convention, which speaks of cultural property of exceptional value. The provision of the Rome Statute refers only to the purpose, to what the building is dedicated to. So I don't think that this particular provision of the Rome Statute can encompass attacks against the environment. I'm a little bit reluctant when it comes to that. So what I always suggest is taking a broader approach to the crimes against humanity of persecution, which seems to me heterogeneous enough to cover acts against the environment. Of course, as I said during my presentation, when we speak about the crime of persecution, we usually deal with a campaign, with a destructive campaign against a particular civilian population. And very usually, at least it was the case during the Yugoslav war, this involves also attacks against the religious objects of certain populations. So, and of course, it could involve crimes against the environment. So that's what I would strongly recommend, to pay special attention to the crime of persecution. Thank you.
Thank you, Pablo. Then there's a question just from Dignita about whether it's possible to send the PowerPoint presentations via email and whether it'll be available on the ICC website. Javier, do you know the answer to that question?
Which question?
Whether the PowerPoint will be available via email and whether the videos will be recorded. I think the video will be available.
Yes.
But
Yes.
we can certainly check. I think from Dominic will let us know.
Yes, I will answer right now. Yes, yes.
Yes, yeah. So another one for you from Ratna. You're a repeat customer. Another one for you, for Pablo, I think. How can the Rome Statute be interpreted or expanded to address environmental destruction that impacts cultural heritage? And what legal precedents or reforms could be pursued to hold individuals or states accountable for environmental crimes that damage both ecosystems and heritage sites?
Okay, Regina, the way I understand this question is like if environmental destruction somehow damages also cultural heritage, so as a collateral damage. But I don't know whether Radna, perhaps he can expand his question by saying whether does the perpetrator have the intent to attack such an object? Yes or no? If it does, then we could be potentially speaking about a violation of Article 8, particularly speaking on the attacks against protected objects. But if it's a collateral damage, if the intention of the perpetrator is not to attack that particular object, I'm a little bit reluctant about how to even resort to a broad interpretation of this provision. Yes. What are the legal precedents of reforms could be pursued to hold individuals or states accountable for environmental crimes that damage both ecosystems and heritage sites? Well, as you know, my colleague Pauline mentioned, the ICC has jurisdiction over individuals.
Yeah.
The International Court of Justice, which is another court located in The Hague, it has jurisdiction over affairs between states. There has been some references to this so-called cultural genocide if I'm not mistaken, in 2007 in the Bosnia case. But the court rejected again this link of the destruction of cultural heritage as a form of genocide. But apart from that, I am not really aware of any other case on environmental crimes at the ICJ level. I know that at the regional level, we could speak about the Inter-Governmental Court of Human Rights, which has, taken a very innovative and creative approach. But again, this is not, let's say, a criminal court. It's not that the International Criminal Court in The Hague. It's a different jurisdiction, if I may say.
Well, thank you. I don't have any. Hang on. Oh, well, Ratna's come back. How international criminal law, particularly through the ICC, could address environmental crimes that have cultural implications while exploring the potential for legal developments under the Rome Statute. This is what I wanted to ask you, if I'm precise this time. I think you just managed to answer that.
Yes.
Pablo. I think that's that.
Yes, indeed. Well, I think I tried to cover this during the presentation. Of course, the Rome Statute, in my view, it protects cultural heritage, so what buildings, let's say, institutions, in a very effective way. When it comes to environmental crimes, I think there is still some room for improvement, but we can always resort to these creativity components that I was trying to support. Thank you.
It's nice to, not see, the black letter law, rigid application of the law. I think we need to become more and more flexible as international lawyers to make it fit, because that's what we do. I think this conversation has been extraordinary, and there's some really incredible legal minds out there, particularly at the Nuremberg Academy. So I'm very grateful to have been part of this. There's no more questions, but we're also coming very close to time. So I think Dominic will be very happy with us for following his instructions. Quarter past is the time that we need to switch off. So thank you everyone for keeping to that time. But thank you for such a great insight. I for one am very much looking forward to more work from you all, and reading that, and be known. It reaches us here in Tasmania, it reaches around the world, and we're all watching, and particularly after what's happened on 9th of September, the next few years are going to be really something to watch, and I'm very, very proud to be part of it. I don't know about you, but when I first started at the ICC, we used to look at the preparatory works and, the drafters of the Rome Statute and the rules of procedure and evidence. And I always used to think, wow, to be involved in something like that, creating crimes that are now, being tested for the first time. And with ecocide being on the table, all this precursory work in the environmental crime work that you're doing, and that will then contribute to ecocide. What an absolute thrill to be part of that, and to be part of creating history in international criminal law. So thank you everyone for your attention. Thank you for a wonderful panel who I hope to see again, whether here or in Tasmania or in Nuremberg or in The Hague. I'm sure our paths will cross at some stage in the future. So thank you. Signing off from Australia, and all the very best to everyone.
Thank you very much to you, Regina. Thank you.
Thank you, Javier.
Thank you so much.
Thank you so
Paula,
much.
Paulina.
Thank you, everyone.
Thank you, Pablo.
Bye-bye.
Thank you,
Thank
Paulina.
you.
Bye.
Ciao.
Bye.
Bye, everyone.